Okay, so you're responsible for devising the law to do with service providers, like ones that do user-generated content, like Blogger and Facebook, or for ISPs. So let's say, for example, someone uploads a video of the latest episode of Game of Thrones to YouTube. Do you think YouTube should be sued for infringing copyright? No.
Stuff gets taken down very quickly.
Right. So, okay, so it gets taken down.
Yeah.
So, okay, so
when you upload video as well, if it's over a certain length, it runs some kind of comparison on it while you're uploading it, so it can match
Right.
that against known.
but in terms of devising the law, do you think YouTube should be responsible for the copyright infringement?
No.
No. Okay. Now, what about if, say, you're an internet service provider and as part of your ISP package, you give someone like web space, where they can have their own little web page, and if someone uploads some MP3 files there, do you think, as an ISP, you should be held responsible for that infringement? No. Okay. What about if someone using your service, a customer, is infringing copyright? Do you think you should be responsible? No. Why do you think no in all of those cases?
Well, for an ISP is what do they call it? Information Society or Information Service Provider.
Mm-hmm.
I know for defamation anyway.
Yeah.
They're not. They're just providing the underlying service.
Yeah.
So I assume copyright would be.
I mean, if YouTube was going to be held responsible for everything that was uploaded, I mean, we probably just wouldn't have YouTube. Like, it just wouldn't exist, as it wouldn't be a thing. I mean, if YouTube was going to... Although, actually, I know when Google bought YouTube years back, I thought, my God, I wonder what they're getting themselves into, like, because YouTube is going to get sued so much. But we have set up the law in such a way that we allow places like YouTube to allow users to interact with it, and we don't hold them accountable under certain circumstances. Also, if ISPs were going to be responsible for everything people did on their networks, it'd be a very difficult business to be in. And they might have to charge us way, way more just to cover their potential legal costs. So we've kind of accepted as a society that we want these things like YouTube and Blogger and Facebook. We've accepted that we, need ISPs. We want access to the internet. So we need to protect them in some way. Do we think service providers and ISPs should monitor their users and stop them infringing?
Well, ISPs no, but service providers like YouTube, they do monitor and there's.
Well, they do monitor, but do we think we should make them monitor? Like, if I was to set up ColinTube tomorrow, should I be required to monitor everything that's uploaded?
Maybe to a certain extent, like.
I mean, you'd be adding to my costs a lot if I had to monitor everything that was uploaded.
Well, I suppose if you don't and you allow infringing content to stay on your.
Well, that's a problem,
you're
yeah,
gonna spend all
yeah.
your time and money fighting claims in court. Ain't you?
So these are the kinds of questions that the law has grappled with and has come up with solutions or sort of solutions. But it's certainly a problem. I mean, if you were to sort of think back with a Statute of Anne 1710 frame of mind, it would be screw you YouTube, screw you ISPs, we're going to throw the book at you. But we are adapting our approach to copyright to deal with the realities of the kind of services that we want and that we think are valuable and useful. So there is this trade-off between the rights of copyright owners and society and its needs. And I think this is a good example of the compromises that brings about. So in the US, online service providers, they're called, and that includes ISPs. So like YouTube, Blogger, they're online service providers, Facebook, an online service provider. And then ISPs are also falling into that category. They can avoid liability for the actions of users under certain conditions. Okay. Oops. Oh. Typo City today. So, there are various parts of the process where copying would take place. If you think about how a file gets from A to B on the internet, if you were into networking, you would know that copies of it might be made along the way. So if we were going to enforce copyright law pedantically, each one of those copies would be an infringement. But basically we're saying to ISPs, you know, if there's a copy made, like if something is being sent legitimately from A to B, if there are copies being made along the way to facilitate that process, then we'll allow that. Okay? And there are a number of criteria we apply for that exemption to be used. So a key one here is that the transmission of the material was not initiated by or at the direction of a person other than the service provider. So it was initiated. So basically, if one of your customers looks for something and it gets transmitted on your network on the way, that's fine as long as you didn't initiate the transmission. Okay? The various technical things that you would have to do to get it from A to B, they're allowed. And no copy of the material made by the service provider is kept for longer than is necessary, things like that. So any incidental copying that happens while something is traveling on your network, that's okay. Sometimes ISPs cache content. So if there is, say, a particularly interesting article in the Irish Times and there's an image in that file that's quite large to download or something, you might find that if you're a UPC customer, when you go to that website, you're not actually getting it from the source. You're getting a cached copy that's been stored locally so that you can get it more quickly. But that's a copy there. But that's acceptable in the US under the safe harbor provision, things like that. And then here, if there's information on your service or on your network, so this is like a YouTube scenario, you're not liable for that if upon obtaining such knowledge or awareness, you act expeditiously to remove or disable the access to the material. So if you're YouTube and you're made aware that there's infringing material on your service and you act expeditiously to remove it, well then that's okay. And so you have scenarios now where rights holders then will say to YouTube, someone has used this song on that video, that's my song, can you take it down please? Or someone has uploaded my television program without authorization, can you take that down please? And so you get takedown notices. So someone like YouTube is protected as long as they remove the offending material once they're made aware of it. Now, you can have some mistakes, and very often if a mistake is made, it gets widely publicized. So you have scenarios where a musician has uploaded his song to YouTube, and then he gets a notice from YouTube saying, we're taking that down because you don't have the rights to it. And he's like, duh, it's my song. But where systems are put in place, for example, to automatically monitor, there can be errors. I had a situation where I made an online class. I made a video using Apple's video editing thing, and it came with like jingles and free music. And so I uploaded that to YouTube. And then YouTube got back to me one day saying, oh, the rights owner of the music in this video claims that you've used this music without authorization. Well, like, he authorized Apple to put it in there, you know, into their product. I mean, Apple didn't just rob it off him. He licensed it to Apple's video editing software. Apple gave me a license to use that and to produce videos using that. So no one had infringed anyone's copyright, but at the same time, YouTube thought they had. And this was an automated process they were using. Now, in fairness, I was able to say blah, 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 blah. No, this came from Apple's thing, and the video was left up there. But you could see how if you start automating the process, you can have problems. And also, lots of rights holders feel like they have an absolute right to their content, whereas we've seen there are exemptions. I mean, there's the fair use exemption in the US. So if someone is using someone else's material and they're claiming it's fair use, often they can get a takedown notice, and the subtleties and complexities of fair use are lost on the service provider. They're not going to take the chance whether something is fair use or not. And so you have a scenario where a legitimate use of a work is being prohibited. Very often, someone will go to great lengths at the start of their YouTube video to say, this is a commentary on a work, or this is a parody of a work, just to straight out of the gate to make it clear that they are claiming the fair use exemption. So takedown notices now are a fairly common occurrence, and there's technology being developed to have them happen automatically, which is a problem. If you take some complex area of law or ethics and you hand it over to machines, you can have some errors. Now, in the EU then, there is this e-commerce directive, which is very important. And Article 12 of that talks about internet service providers or information society service providers being a mere conduit. So if the recipient of the service, okay, or the accessor of the network, right? If they initiate the transmission and the service provider doesn't select the receiver for the transmission and doesn't modify the information in the transmission, then they can claim that they are a mere conduit. So if you're using my network, if you initiate the transmission and I don't select it, so if I was to select people for receiving it, well, then I'd kind of be broadcasting. You know, so if I say, well, there's this video here and I'm letting you and you and you and you watch it, I mean, that's a different thing. But if you initiate it, I don't have a role in selecting it. And importantly, if I don't modify it, why might I want to modify it? what scenario might someone modify it?
To get around detection.
That's one possible thing, yeah. Another one is if this wasn't in there, right? Every time you went to download an illegal video, I could probably slap in a few ads and claim, well, I didn't initiate the transmission and I didn't select the receiver of the transmission. I'm just making loads of money off the ads. So things like inserting ads would have been a modification of the transmission. I must... If I see any more mistakes, I'll just fix them later because it's slowing us down. No. So that's the first thing. So in the EU, we've decided there's an equivalent of the safe harbor. So stuff going on the network is okay, provided you didn't initiate it, select the receiver, or modify it. And here's another very important one then, in Article 15. Member states shall not impose a general obligation on providers to monitor the information which they transmit or stored, nor a general obligation to actively to seek facts or circumstances indicating illegal activity. So basically, you can't say to UPC, we want you to watch everything going on in your network and tell us if someone is downloading illegally. Which is something you might consider doing. But this directive specifically prohibits that. And that's a choice the legislators have made. I think a sensible one. I think you're not going to hold ISPs responsible for what goes on in their network, that's a good choice. But forcing them to track everything coming and going, and then to tell copyright holders when they find something, that's a huge burden, I think, to place on them. So I think that's a sensible choice. But attempts have been made to require them to do so. And SABAM was an industry body representing the record industry in Belgium, isn't it? You have that here in this one here from the ECJ. Is it Belgium? Yeah. And they wanted to force an ISP to monitor and filter the system. Okay. And in this press release here, so this isn't from the actual judgment, this is from the press release, saying the owner of an online service cannot be obliged to install a general filtering system covering all its users in order to prevent the unlawful use of musical and audiovisual work. And it refers back to this directive here. Now you can see why the music, the authors and the rights holders would have been interested in that. That would have been a handy thing. Get the ISPs to do the work for them. However, there's this InfoSoc directive which does say that member states shall ensure that rights holders are in a position to apply for an injunction against intermediaries whose service are used by a third party to infringe copyright or a related act. So they can go to court and ask a court to stop them doing something. So there's a bit of a conflict there. You could see how this does apply to, say, blocking Pirate Bay, but not so readily applies to monitoring and stuff like that. So there's this thing called a graduated response, or 3 strikes and you're out. So this idea that if you're caught downloading stuff, you get a letter explaining, that copyright is important and we need to respect it and what you're doing is wrong. If you keep doing it, we might send you a more stern letter saying you're going to be in trouble. We're going to slow down your internet connection, or we're going to cut you off for a week or something like that. And if you keep doing it some more, we might eventually cut you off. What do you think of that?
I think it was unworkable, wasn't it? Because like you said earlier, you could have guests or next door neighbour hacked into your Wi-Fi or...
There were certainly problems with it. There was certainly the problem that the person doing the infringing wasn't necessarily the account holder. So you're the parent, your teenage kids are downloading all along. Is it reasonable for us to cut off your internet? No, there is a school of thought that says, well, after you get the first letter, you need to have a talk to the kids, or you need to put a password on your Wi-Fi, or you need to explain to Granny that she's not allowed to do that anymore, that you have kind of been warned. No, there are various kind of details, and even the record companies were like, we're not terribly interested in the details, we're open to some sort of a scheme, there's wiggle room on that, with the general principle that you get warnings, and eventually, if you don't cop yourself on, you end up with no internet. Any thoughts on that? What's your reaction to it? I mean, does it seem reasonable?
3 strikes you're out. No, it's a stupid idea.
Yeah. Or 5 strikes, whatever, but I mean, does there come a point where we'll cut off your internet? Does that seem reasonable? It kind of depends. I mean, if they cut it off straight away, that wouldn't be reasonable. So a number of issues came up. Subscriber privacy was a main one. It became clear early on when all this was being discussed that the data protection authorities were simply not having it when it came to the idea of the ISPs handing over the details of the customers. So it meant that the ISPs, if this was going to happen, would have to do the writing to the customer. And of course there was costs associated with that. And the ISPs were like, well, even if we go for this, we're not paying for it. So a lot of the toing and froing actually ended up being about the costs of it.
Suppose you could have a contractual thing as well.
Well, the record companies were saying, listen, if somebody doesn't pay their bill, you cut them off straight away. But if they're infringing copyright, you don't. So like, you can't be saying, oh, these poor people, they'll have no internet. Like, it doesn't bother you at all when they won't pay their bills.
I know, but you might have something in your contract or your terms and conditions to say that.
Yeah.
Cut you off,
Well, they did,
but
in
you
fact.
might
They did have in their terms and conditions, just to cover their asses, don't be downloading stuff illegally.
Okay, but did they say that it will cut you off? That's the thing.
I don't know if they did or didn't, but they certainly didn't have a lot of moral high ground, perhaps. But obviously their concern was, well, if we go enforcing this, then they might switch to someone else. So in the end anyway, after a lot of toing and froing, in 2016, court ordered UPC to operate a graduated response scheme with the record company. So Aircom, Aircom was the number 1 ISP in Ireland and UPC was the number 2. So the record companies went after Aircom first, and Aircom eventually came to an arrangement with them voluntarily, whereas UPC said, no, we're not doing it. And so then the record companies went to court, and eventually, after a lot of toing and froing, it got sorted. And so now if you're a UPC customer and you're using torrents, you can, if you don't cop yourself on, eventually end up with no service. So the idea behind graduated response is that you get a chance and you get another chance and maybe another chance, as many chances, we don't know, but a fixed number of chances anyway. And an important point is that it's the right holder that monitors the activity on the web. So it's the rights holders that are tracking who's doing what. Because you'll recall there's no obligation on the ISPs to monitor. They're specifically allowed not to monitor, and the member state can't force them. So the rights holders can say to the ISPs, look, IP number blah 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 is downloading movies non-stop. Between this date and this date, he downloaded 400 movies. Can you send him a letter? So the ISP then will look up who that person is, and the ISP will send the letter to the user, the account holder. Importantly, the rights holder doesn't get the details. If the rights holder wanted the details, could they get them? What's that called? That was a something order. Can you remember? Norwich Pharmacal order. So if they really wanted to, they could go to court and get one. But as part of this deal anyway, they don't, and the ISP will send out the letter to the account holder. So repeat offenders then get increasingly stern letters. One thing that could be done is their connection gets slowed. So you're not cutting them off, but you are annoying them and disincentivizing, and you're also slowing down the downloads. You know, if it takes an hour to download a movie, that's very different if it takes a week. If it takes a week, you might decide, it couldn't be arsed. You know, so that can happen. Or they might get no internet for a week. Certainly, that would help the dad trying to rein in the kids. Cutting off their internet for a week wouldn't be long putting manners on them. And possibly at the very, very end, internet could be cut off completely. Interesting though, there's no provision for like a central register. So like if you are a serial downloader, you ignore your first letter, you ignore your second letter, you ignore your third letter, you're slowed down, you keep going, you're cut off for a week, you keep going, and eventually you're disconnected from UPC. UPC says, we don't want your business. There's nothing to stop you going and sign up with Aircom next week and starting all over again until you've probably gone through all the ISPs in Ireland. So there's no register, but this is the best they've come up with now. This is the kind of state of affairs as of 2016. What do you think of this? Good idea, bad idea? Any issues you can think of?
It's a good attempt.
It's certainly a good attempt. I mean, it's certainly balancing. I mean, it's certainly a good attempt from the record company's point of view in that it might actually work. You know, the other approaches just didn't. This might actually work. Unfortunately, you're relying on the ISPs. Unfortunately, the ISPs then have to bear some of the costs. And this is a big issue the ISPs had. Like, we'll do this, but you're paying for it, Sony, not us. And so there was a lot of toing and froing about the relative amount of costs. Like attempts were made to automate it so that the files produced by the ISP, by the rights holders, the record companies, could be sent to the ISPs automatically, and they would analyze that and do what they had to do and automatically send out the letters and stuff. And automating it could reduce the costs, but there's a lot of setup involved in that. I mean, certainly having a human comb through the details, log in, look up, you know, copy and paste the letter, print it, put the stamp on it, like all of that was going to, you know, slow things down and be very expensive.
Sure, it's all defeated anyway. It might stop Granny downloading episodes of Coronation Street, but anybody who's into downloading a bootleg can just use a proxy.
Yeah. I mean, you can use a VPN, which basically hides who you are. And really determined downloaders will do that. So then the IP address is no good because all the rights holders see is that somebody in Moscow was downloading Game of Thrones, and there's no connection between that IP address in Moscow and Johnny down in Rossa Avenue. part of the logic was that VPNs are expensive and hard to use, and that you're never going to stop the really, really determined people, but that this does stop the more casual, less technically savvy people. In terms of the cost, they also put a cap on the number of notifications that they could receive every year. But it's a good example of the interaction of different kinds of law, because then we have this problem that an internet connection could be considered as a human right. So the internet is the primary source many people have of communication. So we'll finish this up in 7 minutes, we'll get there. And like, you cut off someone's internet, it's not like cutting off their sky or cutting off their chocolate. The internet is no longer a luxury, it's no longer just for entertainment. It's most people's way of interacting with the world. It's a very important part of our democracy. Much to its detriment sometimes, but it is a part of that. And so the question is it actually reasonable to disconnect a person from the internet in 2017? To say to someone, you can't connect to the internet anymore. And that is a question that's increasingly coming into play that could scupper all of this. So if at the very, 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 very end of the process, you decide you are going to disconnect Johnny from the internet, he could argue, but being connected to the internet is a human right. How can you unplug me? I won't be able to... No, he probably will use arguments like, I won't be able to figure out who to vote for or what I should do in the next referendum. And we might all, knowing Johnny, know that it's all the one to him. But those could be very compelling arguments to present to a court. Or Johnny's mammy lives in France. How is he going to Skype her every night if he has no internet? You're breaking up the family, Your Honour. So this has in fact come up in another context, which we'll see in a second, but the European Convention on Human Rights has an article on freedom of expression, but very interestingly, it points out that freedom of expression encompasses the freedom to receive information. That freedom of expression just isn't about your right to speak. It's also about your right to receive free speech, which actually is very insightful and very far thinking. So if you're cutting someone off the internet, you're interfering with their right to receive information. You're also interfering with their right to impart information. And there was a case before the European Court of Human Rights, a very mundane one, where an Iranian couple who were citizens of Sweden were threatened with eviction from their apartment because they put a satellite dish on the wall outside. And then even when they put the satellite dish inside, the owner of the apartment was still threatening to evict them unless they got rid of it. And they argued before the European Court of Human Rights that this was interfering with their right to receive information. So they were using the satellite dish to get TV programs in Parsi and in Arabic from Iraq. That's why, sorry, it was Iraq, not Iran. My God, sorry, I'll fix that later. Okay, and now at the time, there was no other way for them to receive that information. And so the court held that it was important for them to be able to receive information from Iraq. And that it wasn't just political information or news, that also cultural information that connected them, with their heritage and with their culture, that they were entitled to that also. And so this is quite an important case. Also quite an interesting one. I mean, it means that if you're Turkish, you could argue that you can put a satellite dish in your apartment and no one can stop you, provided you can demonstrate that you can't get that information another way. I mean, if this case was heard today, the court might decide, well, you have Wi-Fi and, you can watch those TV programs online. But certainly, in light of this case, it seems to me it would be very, very difficult to just disconnect someone from the internet. Because there's information on the internet, and not just news, but cultural information on the internet that you can't get any other way. And the European Court of Human Rights seem to be suggesting that you have a human right to that. And it's unlikely that the rights of copyright holders would trump a human right that is enshrined in the European Convention on Human Rights. This court is one of the highest, I attempt to say in the land, but in the lands. I mean, this applies all across Europe. So it seems to me anyway that that's a great plan on the part of the record companies, but when push comes to shove, no court in Europe will forcibly disconnect someone from the internet permanently anyway. So that's interesting. Any questions, thoughts on that?